My name is Daniel Reese. I am a records digitization specialist, which is a more dignified title than the work deserves. For 11 years, I have been paid to feed paper into scanners. I have done it for hospitals, for a diocese, for two law firms, and, beginning in March of last year, for the clerk of the District Court of Hartwell County. I am writing this down because I want a record that exists outside their database. I have learned to distrust databases. The contract was ordinary. Hartwell County is a rural jurisdiction with one mid-sized town, Callaway, and a courthouse built in 1908 that has never been renovated so much as patched. The county had received a state grant to digitize its historical case files, which were deteriorating in a basement that flooded twice in the 1980s. My job was to scan every criminal and civil case from the courthouse's opening through 1999, apply optical character recognition so the text would be searchable, index each file by case number, date, charge, and party names, and upload the result to a cloud archive the state could access. They estimated 18 months of work. They gave me a basement room, a key, a county login, and a great deal of solitude. I want to be clear about the solitude because it matters to what came later. The basement had no windows. The fluorescent fixtures ran the length of the ceiling, and at the far end, past the rows of file cabinets, the light gave out, and there was simply darkness and the smell of paper and concrete. The room was longer than it needed to be. I never measured it, but I had this sense working there alone 10 hours a day that the shelving continued past where I could see into space the courthouse above did not account for. That is the kind of thought a person has when they are alone underground for a long time, and I dismissed it as such. I mention it only because I no longer dismiss it. The work was slow and dull, which is how I like it. I developed a routine. I pulled a banker's box, removed the files, removed the staples and brads, scanned each page, reclipped the file, reboxed it, and logged the case. By my fourth month, I had moved backward through the 1990s, the 1980s, the 1970s, and into the records of the mid-century, when the typewriter gave way in places to handwriting, and the paper turned brittle and brown at the edges. The first thing I noticed was not the man. It was a name that wasn't quite a name. I was scanning a 1974 file, State versus Pruitt, an aggravated assault case. The witness list included the usual: the arresting deputy, the victim, two bystanders, and one entry that read, in the typed format the clerk used, Abernathy, Wang of this county. The blank was not an omission where a first name should go. The line had been typed deliberately, the dash made with the hyphen key struck several times, as if the typist had reached the place where the first name belonged and, finding nothing, had filled it with a horizontal mark and moved on. The address field, which for every other party gave a street or a rural route, read only of this county. I have indexed hundreds of thousands of names. Incomplete records are common. People give false names, clerks make errors. Pages go missing. I flagged the entry with a note in my log, incomplete party data Abernathy, no given name, and kept scanning. That should have been the end of it. It would have been, except that 2 days later, in a 1969 file, I saw it again. State versus Lindqvist, 1969, a fraud case. Witness for the prosecution, Abernathy, Anthony Knowles of this county. Same format, same dash, same address. A clerk's habit, I thought. Maybe a real man, named Abernathy, whose first name nobody ever bothered to record. A known local figure, the way a small town might have a man everyone calls only by his surname. I made a second note. And because I am, by temperament, a person who finishes what I start, I did something I had not yet had reason to do. I queried my own partial database for the string Abernathy. I had digitized about 30% of the files by then, roughly 1960 to 1999. The query returned 41 results, 41 cases, spanning all 4 decades I had so far processed. And in every one, the name appeared the same way. A surname, a dash where the given name should be, and the address of this county. Never a plaintiff, never a defendant in those particular files. Always a witness, an interested party, a person present, once a juror, once in a 1981 probate matter, a listed but uncalled witness to a will. A man does not witness 41 cases across 40 years and never have his first name recorded. That was the thought that made me stop scanning and start reading. I pulled the physical files for all 41 and laid them across 2 folding tables. I read every page on which Abernathy appeared. I was looking for a description, an age, anything that would let me treat him as a person rather than a clerical ghost. What I found instead was a kind of negative space shaped like a person. In the 1969 fraud case, a court reporter's transcript recorded a defense attorney asking a witness whether Mr. Abernathy had been present at the meeting in question. The witness answered yes. The attorney asked what Mr. Abernathy looked like. The transcript reads, A, he's you know him. Everybody knows him. He's just Abernathy. The attorney did not press. In a small county, this is not strange. Everyone does know everyone. But you know him appeared in slightly varied form in 11 of the 41 files, always in response to a question about who Abernathy was. Nobody ever described him. The question was always deflected, and the deflection was always accepted, as though to describe him would be as redundant as describing the courthouse itself. I want to pause here to say that I did not, at this stage, believe anything was wrong. I believed I had found an interesting artifact of small-town record-keeping, a man so embedded in the life of the county that the formal apparatus of the law had simply stopped recording him as a discrete individual. It was, I thought, almost touching. I planned to mention it to the clerk as a curiosity. Her name was Marlene Voss. She had been the elected clerk of court for 22 years and had worked in the office for nearly 40. She was professional, dry, unhurried. When I brought my laptop up to her office and showed her the query results, she put on her glasses and read for a while in silence. Then she took the glasses off and said, "You're moving fast. That's good. The state will be pleased." I said that wasn't quite what I'd come to ask about and pointed again at the screen. The name. 41 cases. No first name, ever. She said, "Old files are full of holes, Mr. Reese. Don't get attached to the holes. You'll never finish." I said it didn't look like a hole. A hole is random. This was consistent. 40 years of consistency. She said small offices develop their own conventions, and a deputy clerk in the 70s might have used a shorthand the others copied without understanding. I said that was plausible, and it was, and I almost let it go. Then I asked her, because she had been there 40 years, whether she had ever personally met or seen the man called Abernathy. She did not answer right away. She looked at the screen, and then she looked at me, and what I saw on her face was not fear exactly. It was the expression of a person deciding how much truth a situation can bear. She said, "Finish the work you were hired to do. The first names of dead men aren't your job." She turned back to her monitor. The conversation was over. I went back downstairs, and because I had been told, in effect, not to look, I looked. I had been moving backward chronologically, which meant the oldest files, 1908 through roughly 1959, were still in their boxes, unscanned. I abandoned my orderly progression and went straight to the earliest box on the earliest shelf. The 1912 files, the courthouse's 5th year of operation, the oldest the basement held, the 1908 through 1911 records had apparently been lost in one of the floods, a fact noted on a water-stained inventory card taped to the empty first shelf. The very first complete case in the very first surviving box was a 1912 horse theft prosecution. Territory the records still use the territorial form in Places versus Coyle. I read the witness list before I read anything else. Abernathy, Atkinwars of this county. Same format, 62 years before the 1974 file. The same dash made by the same striking of a hyphen key, except this was 1912, and the document was handwritten in iron gall ink, and the writer had still made the same deliberate horizontal stroke where the given name belonged, as if the convention predated the typewriter that would later carry it. I sat with that for a long time. A clerical convention can be inherited across a few decades. It cannot survive 62 years, 3 flooded eras of records, the deaths of every clerk who began it, and a complete change in the technology of writing. Conventions decay. This had not decayed. It had been maintained. I went through the rest of the early boxes that night and into the next 2 days, scanning nothing now, only reading. The pattern held without a single exception I could find. Abernathy appeared in roughly one of every 3 significant cases the county had ever tried. Murders, land disputes, the occasional sensational trial that drew newspaper coverage. He was never the accused and never the victim. He was always nearby, always a witness or an observer, or a party with some unexplained interest. And his first name was never, in 100 years of records, written down. And then I found the photographs. In 1947, the county had tried a murder case significant enough that the file included photographic exhibits, crime scene images, and a few photographs of the gallery in the courtroom taken by a newspaper, entered into evidence during a dispute about whether the trial had been prejudiced by spectators. The courtroom photographs showed perhaps 30 people in the gallery. On the back of one print, in pencil, someone had written the names of several people in the front row, identifying them for some long-forgotten purpose. The third name from the left read, Abernathy. I looked at the man the pencil pointed to. He was an ordinary-looking man of perhaps 50, in a dark suit, seated with his hands folded, looking directly at the camera while everyone around him looked at the front of the room. He had a long, plain face. I could describe him, which made him different from every written record in which he could not be described. I scanned that photograph at the highest resolution my equipment allowed. Then I kept working forward through the photographic exhibits, which appeared sporadically across the decades. A 1958 arson case, a 1971 wrongful death suit, a 1989 capital murder trial that had photographs of the jury and gallery, a 1994 civil case with surveillance stills entered into evidence. He was in all of them. The 1958 photograph showed a courtroom gallery. A man with a long, plain face sat in the third row, hands folded, looking at the camera. The 1971 photograph was a wider shot. He was at the back, partly in shadow, but the face was unmistakable and unchanged. The 1989 jury and gallery photograph caught him in the second row of spectators, hands folded, looking at the camera. The 1994 surveillance still, time-stamped and grainy, and entirely unlike the others in origin and quality, showed him standing in the corridor outside a courtroom, looking up and slightly to the side at the camera mounted in the ceiling. In every image, he was the same age. In every image, he was looking at the lens. 47 years separated the 1947 photograph from the 1994 still. The man had not aged a day, and he had known in every case exactly where the camera was. I am aware of how this sounds. I want to record that at this point I considered seriously and in order every ordinary explanation. A family resemblance across generations of Abernathy men. A hoax inserted into the records by a board clerk. Doctored photographs. I tested each one. The family resemblance theory failed because the man's face was not merely similar across the images. It was identical, down to an asymmetry in the set of the eyes that I could overlay between the 1947 print and the 1994 still and match exactly. The hoax theory failed because the documents were physically aged in ways consistent with their dates, the iron gall ink, the brittle paper, the chemical signature of mid-century photographic printing, the magnetic tape origin of the 1994 surveillance frame. The doctoring theory failed because these were original physical exhibits that had sat sealed in evidence envelopes, some unopened since the trials, the seals dated and initialed and intact until I broke them. The evidence was real. The man was in it. The man did not age. That was where the ordinary explanations ran out, and I had to decide whether to stop. I did not stop, and I want to explain why, because the wrong reason would make me a fool in this account, and the right reason is the only thing I am still certain I did correctly. I did not keep going out of curiosity or courage or the genre-typical compulsion to open the door marked "Do Not Open." I kept going because I had already been seen. The man in the photographs was looking at the camera in every image, across a century, which meant that whatever he was, he had always known he was being recorded and had wanted to be. The records were not concealing him. He was using them, and I had spent 4 months feeding those records into a system that would make them, for the first time, searchable, networked, and permanent. I had a professional obligation to understand what I was building before I finished building it. So I changed my method. Instead of scanning forward, I began to map. I built a spreadsheet of every Abernathy appearance case number, date, the role he played, the names of the people the case was actually about. And when I had the names of the defendants and victims and litigants, I did the thing that digitization made possible for the first time in the county's history. I cross-referenced them. This is what the network revealed, and it is the part I have the hardest time writing. The cases in which Abernathy appeared were not random. The people he appeared near did not, afterward, do well. I traced what I could through the records themselves, through later case files and probate records, and the few newspaper clippings folded into evidence envelopes. The defendant in the 1912 horse theft case was acquitted and then vanished from the county's records entirely. No marriage, no death, no probate, no later mention. as though he had walked out of the courthouse and out of existence. The witness in the 1969 fraud case who said, "He's just Abernathy," appeared in a missing persons inquiry 8 months later. The file noted he was last seen leaving the courthouse and was never found. Of the gallery members the pencil had named on the back of the 1947 photograph, I could find subsequent records for everyone except the 3 nearest to Abernathy. Those 3 appeared in no record after that date. Not death certificates, not anything. I want to be precise about what I am claiming, because imprecision here would be a lie. I am not claiming the man harmed these people. I am claiming that the people who came nearest to him in the records stopped appearing in the records. The county's documentary memory, which preserved everyone else with bureaucratic completeness, every fine, every license, every death, simply had no further entries for the people who had stood closest to Abernathy. They were not recorded as dead. They were not recorded as having moved away. They were subtracted, and I was by then the person standing closest to Abernathy in the records. I had touched more of his appearances than anyone who had ever lived. I had broken the seals on the evidence envelopes. My county login was attached to every scanned page. The digital archive logged my name as the last person to access each file. In the system I was building, I was now adjacent to him in every single case. I went back to Marlene Voss. I did not bring my laptop this time. I closed her office door, which I had never done, and I told her what I had found, plainly the way I am telling it here. I watched her decide again how much truth the situation could bear, and this time I watched her decide it could bear most of it. She said the office had always known. Not the details, nobody alive knew the details, but the shape of it. There had always been a man in the county's legal life who was not on the tax rolls, not in the census, not in the property records, who appeared at trials and was known to everyone and described by no one. The first name convention, the dash, was older than anyone's memory. Clerks were trained into it, the way they were trained into the filing system, as a thing one did without asking why. You typed the dash, you wrote "of this county." You did not, she said, look for him, and you did not, under any circumstances, finish indexing him. I asked what she meant by finish indexing him. She said the records had always been a kind of fence, paper, scattered, unsearchable, locked in a flooding basement. A man could be in 40 cases or 400, and no one would ever be able to assemble him, because assembling him required holding all the files at once, and no one had ever held all the files at once. The disorder, she said, was the point. The grant to digitize the records had been opposed quietly by people who were now dead and had gone through anyway because no one could give the state a reason against it that didn't sound insane. You're building the thing that lets him be assembled, she said. You're the first person in 100 years to hold all the files at once, and you've put your name on every one. I asked her the only question that mattered, which was what happened when the indexing was finished. She said she didn't know. No one had ever finished. She said the last specialist the county had hired in the 1990s to do a partial inventory had gotten about as far as I had come to her with a spreadsheet, and had then, 3 days later, failed to come to work, and his apartment in Callaway had been found cleared out, and his employment file had been closed with a notation that he had resigned. Except that she had been the one who would have processed that resignation, and she had never processed it. She could not find him in any record after that week. She had looked. She was the clerk of court, and she could not find a man in the records of her own county. I asked why she had let me take the job, knowing this. She was quiet for a while. Then she said the grant had a deadline, and the state would have sent someone if the county hadn't hired someone. And at least if it was someone she'd hired, she could warn them. She said, "I'm warning you, don't finish. Leave the index incomplete. Take your check, tell the state the basement flooded again, and go home and don't ever search the name again, not even to see if you're still in there." I went back downstairs. I did not leave. I want to be honest that I considered leaving, and that leaving was the correct decision and that I did not make it. And the reason I did not make it is that I had already searched the name one more time before I went up to her office. And I already knew what was in the results. And I needed to see whether it was still there. The query for Abernathy returned by then 103 cases. I had scanned far more of the early files. 103 appearances across 100 years. And at the top of the results, dated to the present month, was a case number I did not recognize and had not scanned, in a format that matched no era of the county's filing, that I am certain was not there the day before. I opened it. It was a single page. It was formatted like every other witness list I had digitized, the same typeface my own scanning software rendered records in. It listed two parties. The first read, Abernathy, Inan of this county. The second read, Reese Daniel of this county. There was no charge. There was no date of offense. There was a field at the bottom, the field that in every other case held the disposition: guilty, acquitted, dismissed, settled, and in this one it was not blank exactly. It held a dash, a horizontal mark made by striking a key several times. The same mark that, in 100 years of records, had stood in the place where a given name belonged, in the place reserved for the part of a person that the county had agreed not to record. I am writing this from a hotel 2 counties away. I left that afternoon. I did not finish the index. I left it perhaps 60% complete, and I deleted my local copies and changed the password on the county login, and have not searched the name since, because Marlene Voss told me not to, and because I am afraid of what the disposition field will say the next time someone looks. I have checked one thing and only one, and I check it every morning. I have a state-issued contractor ID, which exists in a database I can still reach, separate from the county's. My name is still in it. My photograph is still attached to it. I look at the photograph every morning to confirm that it is mine, that the face is the one I shaved that day.